Good morning. We're going to go to phase 2 of this introductory program on environmental law clinics. My name is Bob Kewen. I teach at the Washington University School of Law in St. Louis, where I'm the Associate Dean for all clinical programs, and I co-direct our interdisciplinary environmental law clinic. With me this morning on our panel is Jane Barrett, who will be speaking in a few minutes about her experiences at the University of Maryland. The point of our part of this discussion is to try to raise for you a quite widespread phenomenon in the United States that I'm convinced, whether you've seen it yet or not, you will whenever you run an environmental law clinic and therefore have the possibility of possibly upsetting someone. And that's a phenomenon of outsiders and sometimes even people that own your own university and even own law school, challenging what you do, not just in an intellectual sort of academic sense, but challenging what you do in terms of whether you ought to be doing it at all or whether you're doing it correctly, because you are, quite frankly, stepping on toes or engaged in positions that have been contrary to what some people think is the role of the university. So in my first part of this two-headed panel today, then I'm going to give you a sort of an overview of how some of these disputes have arisen in the United States, specifically involving environmental law clinics, with the goal first of helping to show you a bit of a typology about the kinds of attacks, where they tend to come from, what they tend to raise, and then concluding with some lessons I think you can take away from this that might help you figure out a way to either avoid the problem or to, at least when you're in the middle of it, take care of it. And then, as I mentioned, Jane will, in a sense, do a case study of what's going on here in Baltimore and sort of the sad latest history of this particular phenomenon. So a little over a year ago, I did an article with Bridget McCormick at the University of Maryland where we chronicled over 40 instances in the United States of significant interference in the ability of law clinics to represent clients. I'll just say as an initial matter, this is the tip of the iceberg. These were really just publicized ones that ended up in the press because probably not a law school in America that at some level hasn't felt some sort of pressure, whether it's from alumni or business interests or the university president or legislators, about some activity of some clinic. And as I said, this goes way back. This goes way back, you see, even to the late 1960s, where a clinic at the University of Mississippi was representing some individuals challenging segregationist practices of the schools in Mississippi, which quite upset Mississippi legislators who decided they wanted to figure out a way to end that activity. And it's continued through to today. And even right now, there are at least 3 ongoing disputes involving clinics all over the country. And I want to focus not generally on clinics, but I want to look specifically at environmental law clinics that have been a particular target and perhaps even the target of the most vicious attacks that we've seen here in the United States. And the first thing I want to talk about is a common approach, or a common tactic, common type of effort to suppress an activity of a clinic, and that is to in some way restrict or prohibit the ability of a clinic to represent certain clients or to take on certain sorts of legal matters. This, of course, is contrary to anything we otherwise really know in America in terms of a lawyer, because a lawyer in America isn't specialized, doesn't have a license just to represent certain people in certain ways, but really an effort to try to, in a sense, drive clinics off of certain cases and away from certain clients that some people may think are simply not appropriate for clinics or environmental clinics to be taking on. And I'm sorry that John Bonine seems to have left the room for a minute, but I'm sure he'll be back, because this sadly has a very long history. In the early 1980s and late 1970s, the Environmental Law Clinic at the University of Oregon was heavily involved in representing groups that were challenging timber and lumber practices, particularly the practices in old-growth forest, the impacts of those practices on endangered species. This quite upset the timber industry in the state, it is both very powerful in the legislature and also quite powerful within the University of Oregon. And so they made the argument that it was inappropriate for the clinic at the University of Oregon to be assisting a private party, a private organization, on the grounds that that was an unlawful transfer of public funds to a private individual, and therefore tried to get the clinic disqualified from representing those groups. Fortunately, the Attorney General of Oregon said that was not the case, that as long as there was a public purpose, which was educating the students, the fact that the client might have been an individual or some other organization that wasn't a public entity was not a problem. A few years later, we saw a similar argument made in Rutgers, where it had an ethics law that prohibited state employees from taking positions or getting involved in disputes against the state. And so you can see the argument coming, right, that the clinic at the University of Rutgers is not allowed to ever challenge any state action that might put them contrary to the state. And in an opinion, fortunately, from the New Jersey Supreme Court, they said, no, that cannot be true. It cannot be true that we prohibit our universities from, in some way, and the students that work there or the employees that work there, from taking positions contrary to the state. A matter that's near and dear to me, because for over a decade I ran the Tulane Environmental Law Clinic. It was a vicious attack on Tulane University in the late 1970s for representing citizens who were concerned about a proposal to build what would have been the world's largest polyvinyl chloride plant along the Mississippi River in a poor African-American community that already was just amazingly overburdened with pollution. And my clinic at Tulane got involved, ultimately suing the state on a number of grounds and raising some groundbreaking environmental justice concerns that the Environmental Protection Agency, back in the day when they thought they had the authority to do something about it, was very aggressively involved in looking into whether the state's activities had the effect of discriminating against African-American residents of the state. The governor was not pleased with this at all. He had promoted this project, really brought them to the state. He was very angry at Tulane. He threatened Tulane repeatedly to cut off any funds that the state might have to them. He tried to persuade business groups to boycott Tulane as well. And when that didn't work, he turned to the Louisiana Supreme Court. So in all states in the United States, the student's ability to go to court is through permission granted by the Supreme Court, because otherwise they are not yet members of the bar. But every state has what we call a student practice rule. Generally, the student practice rule simply says that a clinic can represent clients, often it might say, who otherwise can't afford a lawyer. In Louisiana, we of course had a student practice rule. It was fairly broad. It was similar to what I just mentioned. And the interesting dynamic in Louisiana is that the justices of the Louisiana Supreme Court are elected, and that the Chief Justice was up for re-election and had a very challenging campaign against a gentleman who was supported by business interests. So having grown frustrated at the ability to shut down the Tulane Clinic on this case by threats at Tulane, they decided to go to these members of the court who were very sympathetic, since they got money every few years to run for re-election from business interest, to get them to change the student practice rule so that no longer could students represent these community organizations. And here's, I say, a great cartoon about the clinic going up against the state and the business interests in this company. And so they petitioned the court with a letter, and basically the gist of their argument, believe it or not, was not that the clinic had engaged in some sort of inappropriate, unlawful activity under ethics rules or the student practice rule, but as the main letter said, the clinics have taken legal positions contrary to business interests and therefore deserve to be shut down. And they were restricted. So initially, just looking at this issue here of who you can represent, they developed a new rule that made it so that we can only represent the very poorest of the poor, not the working poor, not middle-class people, not a woman who's suffering domestic abuse, but nonetheless still can hold a job. And significantly for environmental clinics in the state, or at least our environmental clinic, which represents community organizations, you'll see at the bottom, we couldn't represent an organization anymore unless they certified that half of their members or more were in poverty, and that was allowed to be discoverable And you can imagine this is tremendously chilling, even if you had a group composed in that way, and really effectively meant that the Tulane Clinic could no longer represent community organizations in state court. We sued. Someone once asked me whether it was the best career move I ever made, suing the Supreme Court of my state. I think it is, because I'm glad to be at Washington University in St. Louis. We sued on constitutional grounds and lost. The reasoning was that the rule did not restrict what lawyers could do. It only restricted what students could do, and students have no right to appear and be lawyers anyway, and so it didn't raise constitutional claims. The next approach that I want to suggest to you that's been taken beyond just who you can represent is money, right? As go after the money, right? Take away the money that funds the clinics. This is a particularly problematic issue with what we'll call public law schools in the United States. I think that's about 40%, a third to 40% of all law schools in the United States, of the 200, are in some way state affiliated, state funding, get their funding from the government. And so the concern here is that since the legislature has the ability to control those funds, is there a way for clinic opponents to use that funding mechanism, a way, again, to shut down a clinic or restrict what it can do? This too goes way back to the University of Oregon, again, a public clinic, and the extreme anger of the timber industry, as powerful there as the petrochemical industry in Louisiana, and we're now finding corporate ag in Maryland. And so they went after the University of Oregon, very long contentious battle to try to get, again, that clinic shut down. One approach which didn't work was just to go after them on ethics matters, right? Every little thing seemed to be a problem. But at least it's been my experience that the ethics committees, because someone made an ethics complaint against me, are very good at ferreting out the nonsense of these complaints and the fact that all clinic lawyers are doing what every other lawyer do. But money's another issue, and this is where it's too bad John Bonai's not here, because I really had to dig up a 1981 Sports Illustrated article about a wealthy timberman who was going to give a lot of money to build a new basketball arena at the University of Oregon. And he decided, after he'd made the commitment, to go back and tell the university that he would no longer support any sport activity at the university until the clinic was shut down. This is a thing you have to be conscious of, right? When someone doesn't like what you do, they may look to their allies elsewhere in the university and seek to pressure you through other parts of the university. And in this case, the pressure, or the theory would be that now the sports department will pressure the law school, and the clinic ultimately will be shut down. Things got much worse over time, so that by the 90s, the viability of the clinic was very, there you are, John, I've been talking about you all morning.
I know, we're listening to you in the breakfast.
Okay, I hope I got it right. The viability of the clinic was very much in doubt because there seemed to be at least considerable support in the state legislature, not just for defunding the clinic, but defunding the entire University of Oregon School of Law. As you can imagine, this created quite a bit of anxiety within the law school and the faculty. And ultimately, the decision was made to avoid that sort of doomsday scenario or the brinksmanship that might come about if it actually came to a vote. The clinic decided to move what we call off campus, to be affiliated with the law school but not in the law school, and to get its funding elsewhere. I've always thought, John, that whatever an educational benefit might have been lost on the student was sort of dwarfed by the environmental benefit, because that group off campus has been kicking some serious rear end in the Northeast for 20 years now, and 30 years now almost, I guess, and people might regret the idea that they should take it away from students and give it to seasoned lawyers. Down in Louisiana, around the same time, again, I was there, we got in trouble in a different way from the one most recently. And that is, I made some remarks and challenged some positions of the governor. He was quite upset. This is a different governor, Governor Edwards, who I think just recently got out of federal prison. He called the dean of the president of the university and sought to get me fired. And that not working, he then threatened to cut off any state funding to the university, no matter its form, right? So Tulane is private, but every university at some level get some money from the state, and its students get money. And he was even going to deny the ability of a student in any part of the university to get any state money to go to school. Much to the credit of the university president, he refused to go forward with that. and the governor backed down. University of Pittsburgh 10 years ago found itself embroiled in some fairly serious matters when it again in that state upset some logging interests by challenging some logging practices in some national forests. Originally, some of that work was done by faculty pro bono, just faculty representing environmental organizations on the side. And the legislators were very upset about that and resulted in a rule, which you might think about for yourself, that no faculty member or any other employee of the law school can use any university equipment, not a computer, not a fax machine, not anything, to do any outside work. Quite a draconian rule in existence. The clinic was put together shortly after that, and it started working on a large road case in the area, very much upset business interests. Again, great deal of pressure on the university. Initially, the university was pretty good about it, so they turned to the legislatures because, again, state-funded university. And down section 11 at the bottom, if I was better at PowerPoint, I would have highlighted this in yellow, included in a budget appropriation bill, which is an easy way to slip something in that, you know, it's hard to fight. You'll see a provision here that no money at all that the state provides to the University of Pittsburgh could in any way support the efforts of the Environmental Law Clinic. This originally was not anticipated to be much of a problem because the clinic there was mostly funded through the Himes Foundation and wasn't really relying on any state money, but the university president decided to interpret this provision to mean that the university could not even provide housing, the building, the computers, the electricity, what we call the overhead or indirect costs, and therefore they gave the law clinic a bill for $65,000 a year for that part of its program, which was really threatened to bankrupt it. Tremendous outcry over that. Initially, the university president was quite dug in, again, because he was being severely pressured by outside groups. Ultimately, after many in the university fought very hard for it, it backed down and decided that it would fund it with university money, whatever that overhead was. A really tremendous statement by the dean, who for a while, the law school was pressuring the clinic to do something and back down, and ultimately came around to the view that that wasn't right. And he said, what do we teach our students when we don't show them how to stand up for those who are oppressed and under pressure? And so he felt the lesson here was worth it for the university to give up whatever might be out there and to fund it itself. Back in Louisiana with the Tulane Clinic, I'm pleased that I was not here for this. The petrochemical industry was still upset because, again, be careful what you wish for. By taking away the ability of the Tulane Clinic to go to state court, they decided they go to federal court and sue them even more. And this was not what they had planned, right? But they'd run out of their weapon at the state Supreme Court, so they decided to go after the money. But the money wasn't so obvious here because Tulane is a private university. So they decided to be very heavy-handed. And so a bill was put forth by the Chemical Association in addition to a scheme to have their corporate donors not give to Tulane. And also, get this, they told members of the Louisiana Association of Business and Industry and the Petrochemical Association, don't hire a Tulane University student in any job you have, regardless from where in the university they graduated. Still not working, much to Tulane's credit, they hung tough. So a bill was introduced which would cut money to any university, all state money to any university, if it did any one of three things: sued any government agency on any matter, sued any individual for damages on any matter in any court, or made any constitutional claim of any kind in any court, including that would, of course, mean in a criminal clinic not representing your client on some Fourth Amendment grounds. Sadly for the petrochemical industry, they pushed this bill about the same time that the BP Deepwater Horizon was oozing oil in the Gulf. They got a lot of bad press and a lot of angry people from around the country, and ultimately backed down. But you can see just the amazing viciousness and thoughtfulness, at least on the other side, of how to go after this, even to the point of denying money to universities, which, you know, as one university president pointed out, they're the economic engines of the states. I mean, much of the wealth of Louisiana is augmented by the great work that the universities do. The final approach I want to flag for you is what I call practice restriction, and that is restrictions that deny a clinic attorney or its students the ability to represent clients in the same way as other lawyers, right? In a sense, making them litigate with one hand tied behind their back, okay? Again, we can look to Louisiana and the student practice rule that the governor got in 1997. The first, Section 10, has to do with the issue of soliciting clients and basically says that the clinic cannot contact clients to let them know about their rights and offer to represent them. You might think, okay, that's good, right? And this is what the Supreme Court said. We don't want to encourage students to learn ambulance chasing. Well, the only problem with the Supreme Court is they didn't read the U.S. Supreme Court's cases, right, that say that a lawyer may, in fact, contact a person and offer to represent them on a matter, provided that the lawyer's motive is not monetary, provided the lawyer's not primarily motivated to make money for themselves, so that you can, and lawyers do every day, contact people about a constitutional rights violation and offer to assist them, but not in Louisiana and not students. So what have we taught them? We've taught them a different ethics rule than practicing lawyers. And at the bottom, you see, they were worried that maybe students were helping people in the legislative arena, so they enacted a rule that basically said that no clinic there can appear in some sort of legislative proceeding. And so much for some of those policy and legislative clinics as well in Louisiana. Ongoing right now, and we're awaiting a decision out of the New Jersey Supreme Court, is another new tactic that public universities here face, and that is requests under what are called public records law, Freedom of Information Act laws, open government laws for documents that the clinic has in its internal files, right? The general rule in America, open government, transparent government, a post-Watergate provision is that any citizen can ask a government to provide copies of documents. And so a disgruntled lawyer, having been embarrassed and defeated by students in the Rutgers Environmental Law Clinic, decided he wanted to see everything in the clinic's files about that case. This is tremendously, or at least potentially, problematic, right? Because it not only threatens to, of course, reveal internal confidential matters that no other lawyer, right, would have to turn over, but it also, of course, threatens to tremendously burden clinics to have to respond to these requests and produce the documents. He sued in court. The lawyer representing the developer originally lost at the trial level, won on appeal. That case is now before the New Jersey Supreme Court. It was argued and briefed, and we're awaiting a decision to see the degree to which, again, clinics might be different than other lawyers, even different than public defenders in the state of New Jersey, and perhaps have to open up their files to clinic opponents. So what does this tell us, right? I mean, there's a lot here, and there's even a lot of other instances involving environmental clinics that I haven't mentioned, and I just want to give you a few takeaways here. And first of all, it's coming to your town, your state, your country, right? At some point, if you're engaged in environmental work, someone's not going to like what you do, even if you're in a policy clinic, right? And you'd be amazed at the belief of legislators that they have a right to control what you do. Even alumni feel that they went there and so you shouldn't sue their client or oppose them. And so be very careful about this and be aware that don't just think this is happening, as many people in the United States thought, oh, that's just those environmental clinics, because it's not, and don't think that that's just the United States. And some of you may have even greater problems, because I know the political challenges in some places pale to what we have here. So just be aware. Originally, some of the attacks were on the role of one state group, i.e. the law clinic attacking another state group, and was that right, that state funds are being used to pay for one group to go after another state group? But today it seems to be about money, right? These attacks on the environmental law clinics now are really about money, and so we've seen an interesting shift in America about what the focus has been of these attacks, away from just the idea that clinics shouldn't get contrary to the government, to that clinics shouldn't be getting in the way of economic interest. And as I pointed out before, be very careful about the state-funded law schools, which are particularly the predominant of these targets because they're so dependent on the legislative process for their funding. That's not to say, however, that it doesn't come from within, right? And some of the biggest challenges clinics have faced have been what happens internally, what happens in the university and law school when these attacks come, and do people stand up for it, or do they start to ask you to do things differently and to back off, right? Often, and I think correctly, academic freedom is raised as an argument, right, that we ought to leave the clinic professor alone to determine the best cases and the best way to handle the cases to maximize the goals of the clinic, including the educational goals. That's important to raise, but outside law schools and outside universities, people don't seem to care a whole lot about academic freedom, to be perfectly frank. I think you raise it, but just be aware that that's not probably the winner with most people. I think that the role of clinics in legal education, however, is a very important argument to make. The importance of that in training the next generation of lawyers. And that seems to particularly work with attorney generals and members of the bar. They understand that, and they understand, therefore, we ought not be mucking around with them. I also think ethics issues are very important to raise, the duties of lawyers to represent clients, the duties of lawyers to be blind to these sorts of external interests and these external pressures on pending cases, and just basically tell people to go away until the case is over. One of the things that we have in America is the phenomenon that sometimes, in fact probably often, people that teach in clinic have what we'll call lesser employment status than other academics. They do not have tenure. Their employment status is vulnerable. They may be year to year, and therefore when the pressure comes, they worry about their jobs, right? And this involves some survey data that we did of all clinic teachers, not just environmental clinic teachers around America. And you can see that this is a real concern, right? When a third of all clinic teachers, you can imagine it's 100% of environmental clinic teachers, worry about, this is just internally, what is my dean going to do? What are the senior faculty people going to do if I get on the wrong way of this? Even to the point of changing what they do, even to the point of making significant decisions about cases and clients that they might not otherwise make because of this particular concern. And here you see just a couple of quotes. Again, these are not environmental clinics, and you see at the bottom, this is the head of the American Association of Law Schools noting as her role as a former dean of the law school and head of now the Association of Law Schools. This is happening. This happens all the time. Deans constantly get questioned about their clinics. This picture is to remind me that senior faculty, therefore, within your institutions are very important. The Bob Percivals of the world, as you will. Because when the pressure comes, somebody internally has to help you. Somebody's got to make your case. Somebody's got to quiet the faculty, quiet the dean. And in the case of the University of Pittsburgh, even go across campus and get the faculty senate to weigh in and to see what outrageous attack on academic freedom it is when the university seeks to charge a clinic $65,000 just for the right of educating its students. I do think that also, noting the important role that clinics play in access to justice and providing representation and voice to people that aren't represented is very important in your strategy, and having sympathetic stories available to tell people how this works. Stories work, you know, and people and pictures and faces work. And clearly the support of outside organizations in the United States, public officials, environmental organizations, the groups of lawyers and all the rest are very important. And so I'll close on that theme, right? And that is, think about the media, right? Those of you who have an extra 99 cents while you're here in the United States could go on Amazon.com and buy this movie about the conflict at the Tulane Environmental Law Clinic, which was on television some years ago. And the fact that it's 99 cents is no indication of the quality of it, but just that you can get good deals on Amazon. But media stories are very important, right, to move public opinion, to move either elected or appointed officials to move a certain way. Sympathetic groups, as I said, are important. It doesn't have to be an environmental group. The League of Women Voters is a really straight-laced, good government group that in Louisiana saw the problems and used their influence to try to move people. American Bar Association, group of lawyers in the United States, has come out very strongly with a general resolution that commits the organization, when these disputes arise, to step in and help out clinics of any kind. The American Association of Law Schools, or the Association of American Law Schools, you know, our umbrella organization that all law schools belong to, too, has seen this problem and has a standing position on it and is ready to step in. There are clinical organizations and environmental organizations, too, that have seen this problem and step in this particular case in Louisiana, you see a few years ago, to write letters and other things to try to get the legislature to back down. Here again, reaching beyond environmental professors to Association of University Professors across America who are very concerned about what this means for academic freedom generally and the ability of universities to take on matters that might be contrary to business interests. Here again, the American Association of Law Schools, not just with a policy statement, but willing to actually write and use its influence to move decision makers. And then the ABA. The ABA recently has been, again, very, very good, and the ABA moves people because many legislators are members of the American Bar Association and lawyers, and surely it helps influence state attorney generals. And amicus briefs. Many of us have been involved as at the organizational level in filing amicus briefs when these cases go to court to try to point out to the court some of the things I've just mentioned, the important role of clinics and legal education, the important role of respecting the ethical obligations of a lawyer, the important role of respecting academic freedom and leaving decisions about what's the best way to learn at the university level and not in the halls of an elected body. And finally, I'll note, Godspeed that you never end up in this situation, but we now have a fairly extensive bibliography of all these cases across America, that what's been filed in those cases, some very good briefs, some very good policy papers and other things. This is through the American Association of Law Schools website, but since I put it together, should you need access to it, just send me an email at Washington University in St. Louis, and I'll do what I can to get whatever we have. So with that very sad history out of the way, I'll turn it over to Jane.
Well, first, what I'd like to do is welcome you all to hot, steamy Baltimore. I wish that I could tell you that the temperature was going to be lower, but it's not. We don't usually have 100-degree temperatures this early in the summer. We always have humidity, but not. But please, I hope that you'll be able to enjoy our city and the time you spend here with us. So now we're going to go from the macro, what Bob has been talking about, and then also what Kim talked about earlier in terms of the university's clinical experience in the United States, and talk very specifically about the experience that we've had here at the University of Maryland Environmental Law Clinic. And what I want to do in order to set the stage is tell you a little bit about the history of our clinic, how we're currently structured, and then some background about our case that kind of will lead us into the political interference. Our clinic was established 25 years ago by Professor Percival and is a integral part of the clinical legal education here at the University of Maryland, which has a very robust clinical legal program. I think we are the only law school in the country where it is mandated by our state legislature, it's called the Carden requirement, that all students must have at least one semester of representing or working with access to justice issues before they can graduate and get their JD. So that was a legislation that was passed back, Bob, was that before you came, the 80s? I think it was in early 1990s. We are, in fact, the only public interest law firm in the state of Maryland. It's interesting, Bob talked about you can't solicit clients. I don't have that problem. My problem is I have to turn so many people away, and I can't find people to represent them. We have a limited capacity because we are doing a dual function of education plus litigation, and it's just very frustrating that we aren't able to help everyone who needs help. And our goal is, at bottom line, is to train this new generation of lawyers to work in the public sector and protect our health and safety of our environment. The clinical structure here at the University of Maryland is there's a director, myself, and I am hard money. The university pays for my salary and everything. Since I came here in 2007, I'm just finishing up my 5th year, I've been fortunate enough to get grant money, and we have expanded the grant money each year to the point that I have a staff attorney who is grant funded, and you may see Andrew around here. Andrew Carey, he's not here this morning, but he's graduated from the clinic 2 years ago and he was a fellow for 2 years, and now he's been promoted to be the staff attorney. We also have graduate fellows who are, 2 of them are sitting in the back. I'd like you to wave your hands, Aaron and Matt. They are graduated last year from the University of Maryland and were part of our clinical program last year, and this year have been fellows, and we're going to be starting their 2nd year this coming year. So if you have questions about them, to them about what the clinical experience has been like, please reach out to them. And I also want to introduce you to Chris, wave your hand, Chris, and Pat, who are also former clinical students. And Chris works at the U.S. Environmental Protection Agency, and Pat works for the State Maryland Department of Environment. And they can probably give you more of a sense of what it's like to be a student and what you take away from a complex litigation clinic than I can standing up here talking to you. So I would invite you, I'm hoping that, I know that Aaron and Matt and Andrew will be around, but I'm hoping that Chris and Pat will give you an opportunity to chat with, to talk about their clinical experience. It's a 2-semester clinic. Students get a total of 8 credits. They must bill between 3.3 hours a week as an average, but most of my students put in 22 to 25, and some have been known to put in 30 hours a week on their clinic work. So they're also carrying other cases. Predominantly third-year students, although I do have some 2Ls, and one of the best things about the clinical experience from my perspective is how the 3Ls really work to help develop the 2Ls, and it's really a kind of a collaborative learning process. In addition to the casework or the assignments they get, we have a 2-hour practicum session each week where we talk about the basics of the Clean Water Act, basics of oral advocacy, basics of writing, and all the issues that are involved. And then they also work with us on their assigned cases. Although we're going to be talking about Big Ag and our case against Purdue and one of its growers, that is just one of the cases on our docket. We do environmental justice work. We're working on 2 coal ash pollution cases. Purdue is the factory farm case. We have a case suing the state of Maryland for transparency of records under our Public Information Act. And in addition to that, the bedrock of our clinic is the commenting on permits, both Clean Air, Clean Water Act permits and regulations, so that we have a good foundation for the industries in the state. Okay, so that's us. Let's talk a little bit about the Chesapeake Bay. We'll see the Baltimore Harbor, and you'll be on the Baltimore Harbor, which is part of our wonderful Chesapeake Bay. The watershed goes all the way up to New York, and the bay empties into the Atlantic Ocean in Virginia. Maryland, as you can see, has the benefit of having most of the usable space, although I guess Virginia has a lot of it too. Sadly, it has been in decline, and the federal government and state governments have literally thrown buckets of money, billions of dollars in the last 20 years in an attempt to save the Chesapeake Bay. And the 3 biggest problems are nitrogen, phosphorus, and sediment. And you can see that agriculture is a big piece of that. And for those of you who aren't familiar with our state, on Maryland's eastern shore, if I go back a slide, I don't know how to do that. I got the two. Oh, I don't know. Okay, so you can't see it. If you look to the left, no, to the right of the Chesapeake Bay, where it's next to Delaware, that's what we call Maryland's eastern shore. And that is predominantly agriculture. That's the only really thing going on the Eastern Shore is agriculture and tourism. Those are the 2 things. So any challenge to bring agriculture into compliance with the Clean Water Act or to minimize pollution is guaranteed to be a lightning rod for opposition by agriculture. And as with most of the United States, agriculture is big ag. And by that I mean corporate agriculture. It is not, although they portray it to be small individual farmers, it is typically the big ag that is causing us the problems. Phosphorus and nutrients are a big problem in our healthy bay ecosystem, and one of the biggest threats is irresponsible agriculture practices, which we're going to talk about in a minute. Factory farming is a part of the agriculture problem, and it's interesting that when the Clean Water Act was passed back in 1972, Republican Senator Bob Dole articulated the problem of factory farming, which is when you concentrate animals in a very small area, so you have a lot of animals generating a lot of waste product, then you're going to end up creating a situation where the receiving streams are receiving all of this concentrated waste. The one other thing I wanted to point out, kind of as a precursor to talking about the case specifically, is that our statutes, federal statutes, provide Clean Water Act, all of our federal environmental statutes have citizen suit provisions, which allow citizens to enforce the terms of the statute. And it is viewed as a supplement to government enforcement of a statute. And there's a great quote, which I forgot to put the case in, a case that the baykeepers in San Francisco or San Diego Bay brought, and the Ninth Circuit clearly stated that, this statute is there, this provision of the statute's there for those situations when government either can't or won't bring enforcement. And so we have that as a tool, but that has not stopped the critics. So what is the case that has just been the trigger for all of this adverse action by our state government? In October of 2009, the Asitude Coastkeeper, who is a local NGO, part of the larger Waterkeeper organization, observed piles of what she thought was chicken manure that were close to a ditch on the eastern shore. They sampled, and very, very high levels of nutrients and of bacteria were found. That led to a notice letter, which is basically a letter to the violator saying, we've got this problem, let us know what the answer is. They have 60 days. We also have to notify state and local governments so that they can take corrective action. What happened after that was very interesting. The farm, which is called the Hudson Farm, is under contract with Purdue, which is one of the integrators, chicken producers. I don't know if anybody, you get Purdue chickens, but they're everywhere. And Purdue's response was immediately, oh, it's not a pile of chicken waste, it's just biosolids, don't worry about it. Well, unfortunately, that was still causing, even if it was biosolids, it was still causing a problem. So MDE goes out and they do their investigation, and I'm going to skip ahead because we filed our complaint in March, but this, can you see that? Yeah. Okay, so you can't really see it, but this is a picture of the farm, and MDE sampled upstream of the chicken houses. Now, the two long rectangular buildings are the chicken houses. They are built up so that there's a natural swale between the two of them, or actually it's a man-made swale between the two of them. And that swale feeds into that ditch where you can see the arrows. Upstream of the chicken houses, virtually no pollution was found. Downstream of the chicken houses, particularly in the middle of the picture, they found 300,000 levels of E. coli and, a fecal, and 241,000 of E. coli. No other sources other than the farm itself. And based on that sampling data and the sampling data that the waterkeepers had taken for 12 others, on 12 other dates, the lawsuit was filed. That's where, I'm going to slide, that's where the fun began. So we filed the lawsuit, and immediately, and back in 2010, the state legislators tried to stop it, and they did two things. They first tried to do a piece of legislation that would prohibit us from bringing the suit, but since we brought it in federal court, like Tulane had done, they couldn't do that. So then it was a budget amendment. We got amazing response from our colleagues, and it was a very short turnaround. Because it was a budget amendment, we were pretty stunned. We found out about it like in a late weekend in February, and the bill was going to be introduced the following week. And within 7 days, we had generated, thanks to our colleagues at law schools across the country, universities across the country, our students and alumni, over 470 letters that were hand-delivered to the legislators. And we made copies enough copies for every single member of the General Assembly. You can imagine when they were plopped on their desk. And one of the themes was, hey, we're a liberal blue state. We don't want to be like Louisiana. You guys can't do this. And fortunately, they backed off. And the only thing that happened that year in 2010 was that the law school was required to prepare a report on publicly filed cases that had been filed in the last 5 years by the Environmental Law Clinic. We didn't have any problem with that because that's all public information anyway. You know, gave them our docket and case numbers. And so we thought, it's over. They're never coming back again. You know, we won't have a problem. So we continued to work on the case, and predictably, defendants filed a motion to dismiss the case. And this is where you can see the article about funding is restored. And I'm presuming that these PowerPoints will be up on the website, and if they're not, let me know and you can have the details. So what happened then was everything's kind of mellow, and we kind of go into our fall 2010 and spring of 2011 when we are engaged in what is known as discovery. We're doing depositions, we're doing document requests. You know, we sail through the 2011 legislative session, no problems. We think it's over. And unbeknownst to us, in the spring of 2011, Purdue, masquerading as a grassroots, you know, farmers outraged website, set up a website that was housed on Purdue's, that is currently housed on Purdue servers, and they just kind of had it sitting there. We were originally supposed to file our motions for summary judgment in mid-September of 2011. At the 11th hour, that date got bumped, but the website, SaveFarmFamilies.org, went live, and that was in September. And Purdue uses Levitt Communications out of DC, and they've admitted to journalists that they do, that they are contributing to the funding of this website, which is a crisis communication firm. And if you go on their website, their advertisement is, you know, what do you do when, you know, you've got a bet the company kind of case? Come to us, and we'll manage your communications. And as an aside, the really sad thing about this is, based on my contacts with other members of communications firms, Purdue's probably spending $30,000 to $50,000 a month to manage this website. Correcting the farm, we'd only need about 3 months of that money, and we'd solve the pollution problems. So that kind of tells you where the priorities are. This is the picture of the website, and at the top, they show you the grower's wife and children. The video is heart-wrenching if you go on it. I would donate to it in a heartbeat if I didn't know the real facts. They list on the other side all of the contributors, and you'll notice if you go in and read it that it is every national big ag company. There isn't much local about it. And the other interesting thing is this is not a 501c3 organization. So they have a little disclaimer that if you donate to this, it's not tax deductible, but you may deduct it as a business expense. But what that means is we have no idea. If it were a 501c3, we would have access to knowing what their money was and how much they were getting, and what, you know, we have no idea how much they've raised, how much they haven't raised. They claim they've raised close to $300,000 for it. But what is more important is on a almost weekly basis, there is a press release issued from SaveFarmFamilies.org. And it is a press release on anything they can think of related to the case. And it is distorted. It repeats the same themes that they started with, which are inaccurate. And it has a life of its own. And if you go and do on the web hit, you're going to find out that most of the hits, if you're doing SaveFarmFamily.org, makes the clinic look like the biggest monsters in the world, because we and our clients have not figured out a way to offset that. Here are the key statements that are the themes that are coming out. Stand up and protect struggling farm families. The water keepers, my client, are a bankruptcy by litigation tactic. Mothers have to go back to work because of this case. And we're destroying the farm family lifeblood on the Eastern Shore. It is a well-coordinated social media campaign. They have strong, organized alliance and coalitions. They have spokespeople everywhere. It's emotional. And it really, all they do is redirect away from the substance of the case, away from the facts of the case, to the facts that they want to portray, redefine those, repeat it constantly. And it is effective. After this, in 2010, we had legislators across the board who were supporting the clinic. They didn't even ask questions. Once this website went live and it started getting pummeling, our legislative friends were coming to us and saying, why are you putting a farm out of business? And it was this disconnect of, do we really want to be perceived as with the clinic as against the family farm? So it was very effective in the political arena. So here's one of my favorite cartoons, not because it has my poor Dean on it, but their one big theme is our client is this rich organization, which is not true, and against the family farm. And if you read the stuff on the net, you would not think that the victim was really the Chesapeake Bay, which it is. And you would not think that the Environmental Law Clinic, think of Remember My Staffing, is the underdog. They talk about our limitless resources as if we have, I don't know where they're getting that, but that's another theme. They never mention the Chesapeake Bay, and they never mention Purdue, which is a multi-billion international corporation that is a defendant in this case. So we were getting ready to file our motions for summary judgment on November 17th. And late in the afternoon, the dean received a letter from the governor. And almost instantaneously, I received this forwarded email from a member of an NGO who obviously got it on the night before our motions for summary judgment were due. And it is from the governor's legislative office saying, here's a letter we're sending to the dean tomorrow, and we hope that it's well received. And so I kind of cut and paste because I'm not real good, but this is the substance of what of the governor's letter. Very concerned about bringing a costly litigation of questionable merit. Now, mind you, no one from the governor's office had ever contacted anyone, plaintiffs, me, law school, anything about this case. No one. Focus on the Hudson farm being in the family for 100 years. Talks about he's not dictating what the clinic should or shouldn't do, but the case is using an economic weapon of unlimited litigation resources. Duh? State University? And we're using taxpayer-supported state resources to bankrupt and destroy a family farming operation who has no resources. This is not what, and he attended this law school, this is not what we were taught about the high calling of justice when I was a student at the law clinic. Our clinics should help the too often unequal playing field. And he suggests that we should have been representing the Hudsons rather than suing them. And he calls it a significant injustice and an ongoing insignificant injustice. So that was sent, as I said, November 16th. We filed our motions for summary judgment November 17th. And the dean gave a very forceful, responsive letter, basically saying, Governor, this is a matter in federal court. There's litigation ongoing. You know, it's more appropriate for you not to be saying this stuff. Well, one of our clients, I'm going to Food and Water Watch, actually they're not a client, they're an NGO who we collaborate with, had sent a Public Information Act request to the governor's office after the governor sent his letter. And Bob may remember this, but when I read the letter, I went into his office in Rena Steinzer's and I said, you know, this is so bizarre. It is as if someone from Purdue was dictating the letter and whispering in the governor's ear. Little did I know. Food and Water Watch got over 70 emails, and although the case is not mentioned specifically, there is one email that is a particular note, which was issued from the general, and he was communicating with the general counsel of Purdue back and forth on his state email. The day after the letter, on November 17th, Herb Friedrichs emails the governor and says, very nice, obviously referring to the letter he'd sent. If you look at the history of the governor's emails with Friedrichs, you find out that they are in close communication, sometimes on a daily basis. And I'm going to go back, and I want you to hold that thought, because after the governor's letter, we were starting the legislative session of this past year, and almost instantaneously, the attack was on from our state legislatures on the Eastern Shore. The first thing that came after the governor's letter was a letter from Senator Coburn, who represents people on the Eastern Shore, asking for an explanation as to why we were representing the rich water keepers, and he asked a few other questions. And over the course of the next several months, there were several bills that were introduced. One that had legs much longer than I expected it to was a bill requiring the law school to reimburse the Hudsons up to $500,000 in attorney's fees. That one got out of committee, which we were surprised, but did not get through the Senate. There were various funding restrictions, everything from taking $500,000 from the university system here at Baltimore's budget to give it to the University of Baltimore so they could start a farm clinic, to using that money to assist make the University of Maryland start a farm clinic. There were every variation. There was a bill limiting along the lines of Tulane who we could represent, saying that we could not represent any non-governmental organization, that the only people at all, no matter whether they needed representation. At the end of the session, what we ended up with was the transfer, was a directive in a budgetary note that $250,000 of President Perman, who's the president of the University of Maryland at Baltimore, which is the professional schools, law school's part of it, $250,000 of his legislative budget funds must be spent on doing a needs assessment of the farmers' legal needs. So that's kind of plays into what Bob was saying, is you can understand when you've got that kind of pressure being put on your president, it creates some uncomfortable moments. And I have to say that I'm very proud to say that neither he nor the dean nor any of the other deans of any of the professional schools have we gotten any kickback from. We haven't been pressured to drop the case. We haven't been pressured, to have a lower profile. Everybody, of course, would like it to go away, but they recognize that it's not. But that is the power that the legislators have. And it is the power that corporate America, and I don't think it's corporate America, I think it's global corporate companies have to interfere and to lay a message. And Governor O'Malley hasn't stopped. The emails, that go back and forth, as late as June 27th, he gave an interview. And it really tells you something. I mean, he's still talking about, the Berlin farmers, Alan and Kristen Hudson. He's not talking about Purdue. And it's kind of like nobody's thought about, hey, Purdue's out there. They're the big bad guy. They're the guys that are own the chickens, that benefit, that make the money. And O'Malley still is articulating being the spokesperson for the defendants in this case. He talks again about compounding the injustice. And, you know, the most interesting thing I thought from those of us who practice Clean Water Act law was his comment that this isn't not a point source pollution, so it must not be something we need to deal with, and that everybody other than farmers need to clean up their act. He obviously didn't see the graphic at the beginning of my power presentation about ag's contributions. Okay, since we're talking about clinical legal education, I want to end with student reflections. At the end of the school year, I asked my students to reflect on their clinical experience. And not surprisingly, this year, many of them reflected on the political interference and what the lessons they take away from it. Most of them were shocked, absolutely shocked, that a sitting governor who was a lawyer and graduate of this school would attempt to interfere with ongoing federal court litigation. And it was an eye-opening experience for them. But they all appreciated the learning experience and appreciated being taught this early in their career the nuances of there aren't always just white hats and black hats. It's a very complex legal system we live in. One other student reflected that she was naive, but that and her comment that it's easy to get caught up in the idealistic win or the all or nothing win, but realize that that's really not how the real world works, especially in the field of environmental law. And that what we need to do is understand that we won't always win, but we have to keep trying and we have to keep pushing the envelope, and which is something that I try to leave, the message I try to leave with students. So with that, and as I said, this stuff will be available to read. I think we'll take questions at this point.
What's the political opposition to the governor doing or saying about the issue?
There is no political opposition. The problem in this state, which is a weird thing to say, is it's a Democratic state and it's controlled by the Democrats. And the dynamic has been that because the governor is the head of the party here in the state and has so much political power, many NGOs are not even willing to come to our support because they don't want to get on his bad side. Republicans are going to take the same position. They're going to be pro-farm, pro-ag, so there really is no opposition.
It's a frightening story, and I think that there's experience to relate from Canada that's parallel, not in a clinical sense, but this speaks to the entire environmental movement. There were very public attacks on quote unquote foreign funded radical environmental groups who were trying to stack the deck against the development of a major pipeline project, the Northern Gateway Pipeline, which is coming to be seen as Canada's Keystone XL, and the polarizing the polarized discourse that is emerging in our country is one of, you know, if you're in any way challenging industrial development or pipeline development, you are becoming you're 100% against the interests of the current federal government with our Prime Minister Stephen Harper. It's a very challenging situation where we find as well eco-justice, which is, you know, the major, the big public interest environmental law organization. There are many groups who simply won't be associated with us anymore, who don't want to engage with us, even if it's a matter of law reform that's not particularly controversial. They don't want to engage because they don't want to be seen as working with us and to potentially damage relationships with a federal government that may well be in power for the better part of a decade. So very challenging circumstances, and I think that the pressures that Jane, that you're saying have been borne by the president of this university and the dean. That kind of solidarity is so important, and I would simply point to go back to our earlier theme around institutional partnerships, and in circumstances where you have an NGO like EcoJustice partnering with the faculty, that kind of situation can get even more tense, because all of a sudden it's not the law school's clinic per se, it's the law school with an NGO, and we've run into similar situations ourselves in our short 5 years of existence. And to the credit of the University of Ottawa, they have backed us up as well under similar duress.
So one thing I think you might be interested in the history of environmental law clinic associations with NGOs in the United States is the very first clinics. I think the first 4 were all clinics that were funded by and joint operations of the National Wildlife Federations and the schools themselves, Michigan, Colorado, Oregon. And they had to drop that because the perception was, and was used as a weapon against the universities, was that the university ought not be a handmaiden to these NGOs. They ought not be doing this. It violated the institutional neutrality of the university. And so for those of you who are working with NGOs, I don't know if that's coming, you know what I mean? It's just not really worked here. And really none of the clinics anymore have that kind of close partnership, I think, with the exception of Stanford, which I think can get away with it just because it's just a big, rich, powerful university and nobody seems to understand the relationship. So.
When I was interviewing to become an environmental clinic professor was when the stuff in Tulane was happening. And so literally people were constantly warning me about don't grow up and be Bob Kuhn. So, but he's become one of my personal heroes. And I've listened to you talk about political interference and the importance of environmental law clinics over the years. And the messaging that I heard today was more dire and more negative than I've heard from you before. And so I'm wondering if you have anything more upbeat to say, because it was kind of warning, warning, warning. You're one case away from bad things happening, and it kind of is a little disparate from Maria's opening saying, "Hey, let's create more of these. Let's do more. This is a more important thing." So I'm just trying to get back to I've heard you say more positive things in the past. Has there been a sea change, or what's going on?
So I'm sorry. I'll say 2 things. My purpose here today was just to really to warn people, not warn people off doing things, but to warn people about what's out there and be smart, right? Understand that this is out there and think a little bit in the design of your clinic about what's going on. If you think about it, these are really almost all success stories, right? So the success story at Oregon is, as I said, be careful what you wish for, because they pressured it out of the University of Oregon. It's now associated with the Western Environmental Law Center or whatever, and it does more tough, hard-nosed litigation than it could ever do at the clinic. Tulane is still up and running really strong, and as you could see, running a little too strong for business interests because they're still trying to figure out new creative ways to shut it down. The Pittsburgh clinic weathered that storm and on some level brought the school together around the idea that it's totally inappropriate for any part of the university to come under that sort of pressure. I am confident that we will come through what's happened at Maryland. I mean, in some respects, we came through the legislative sessions twice and survived. I think I told you this, Jane. I'm not sure. My experience on a personal level, having been through this, and is that you and your students are better for it. As you can see from the student observations, it's a really defining moment for people. It was a defining moment for me in my career. It's a stressful, terrible thing to be in the middle of. I don't wish it on anyone. But nonetheless, you're standing up for the ideals of education, legal education, the bar, and everything about it, and so I don't I don't wish otherwise for myself, I don't wish it on anybody. But I think at the end of the day, if you stick with your guns, and I think the message here today is be careful and be smart about these things because they're out there. But I hope no one takes this message to me. Don't go not suing the meanest SOB in town just because you're worried about what the meanest SOB in town will do to you. You just have to think about how you go about it and what might happen if they come back at you. So.
And I just want to follow up on that. I have to say that the bonding, and I'm going to, Matt and Aaron and actually even Chris and Pat and Andrew, I mean, the going through a firestorm really defines you, and it really pulls out of your students their backbone. And I am never more proud of my students than when they're facing the difficulties that they do, and they even hear it from some of their classmates, and they are so proud and so determined that they're going to do the right thing and to continue the representation. And I've had a long career. I was a prosecutor, state prosecutor, federal prosecutor, defense bar. I'm teaching, and I've really never felt closer to the true idealistic sense of the practice of law as I do working on these types of cases. So I think it's professionally just an incredibly rewarding, notwithstanding the firestorm. And what I didn't get to, there are lessons learned. There are things that I would do differently, and maybe that's a panel for next year, do differently, knowing that I was stepping into a very hot button item, which I frankly wasn't aware of at the time I did it. But there are things you can do to prepare.
Just for a moment, speaking as the chair of the Academy, Rob Fowler, can I just thank you, Bob and Jane, for just a really inspiring couple of presentations, even though the message was quite intimidating. I think it's also really significant. And I think just responding to that from the Academy's point of view, and given this is the first time that we've actually looked at the question of the role of clinics in environmental legal education, there's a couple of things that clearly we can take away from it. I was really struck by the fact that bodies like the AALS have now got positions in relation to clinics, and I think we should really, as the Academy, from a global perspective, do some work around that ourselves. So I'd give you the undertaking that we'll examine that possibility. I think also listening to that story, Jane, of the 400 plus law schools who came, riding to the rescue, if you like, or to the support of your clinic, with a global network of the kind that Maria is contemplating, we could perhaps, add some extra weight to that from a broader dimension as well. So I think there's some really valuable outcomes from what we've heard today, and I hope that we can, as the Academy, make our small contribution to supporting what's a very important part of the legal education process for environmental lawyers.